Hello, Con Law students. This is a lecture on equal protection for Module 8. In this lecture, I will discuss the general principles of equal protection, going over the introductory material that your textbook also provides. I'm also going to explain the analysis that courts use in equal protection cases. Then I'm going to discuss voting rights issues that are currently before the U.S. Supreme Court. And this is new information that your textbook does not address. So you'll need to pay particular attention to that portion of the lecture and take good notes. As well, for this last point, I will discuss affirmative action and the court's current position on its validity. And this is also going to involve a new decision that is not covered in your textbook, so you'll want to make notes about it as I discuss it. Remember that the phrase equal protection refers to civil rights, and that civil rights are collective rights. You can consider the concept from two perspectives. Civil rights refers to the right of a group of people to be free from unequal treatment, or it can refer to the obligation of government to treat people equally unless there is a sufficient reason not to. Start off with the premise that governments can treat people unequally. Many laws do so, and for good reason. What our laws prohibit is invidious discrimination. Invidious discrimination refers to discrimination that is based on ill will or hatred towards a group because the group shares a certain characteristic. Within months of the end of the Civil War, Southern states, the former Confederate states, enacted laws that treated African Americans unequally. They were known as Black Codes, and their primary purpose was to ensure that white planters had a cheap labor force. If they couldn't have slaves, then they would have the next worst thing, a group of people whose freedom to gain employment was restricted to farming, but had no land to farm, and thus had to work the farms of the white planters, the very farms where they had been slaves just months prior. Some examples of black codes enacted in South Carolina were that black people could not hold any occupation other than farmer or servant unless they paid an annual tax of $10 to $100, which, mind you, was quite a bit of money in 1866. Black people were given heavy penalties for vagrancy, meaning that they could not walk around their community freely, but had to remain on the plantation where they were working. The 14th Amendment was ratified to target those disgusting laws. And the Equal Protection Clause of the 14th Amendment reads that no state shall deny any person within its jurisdiction the equal protection of the laws. The 14th Amendment also includes an enabling clause that Congress shall have the power to enforce by appropriate legislation the provisions of this article. The purpose of the 14th Amendment was to eradicate black codes and to protect former slaves, particularly in the South. That animosity toward black people, those black codes, are the clearest example of invidious discrimination. But beyond black codes, what is considered invidious discrimination has changed somewhat over the course of history as Americans became less tolerant of racism. The easiest example of that is the separate but equal doctrine that was upheld in 1896 by the Plessy versus Ferguson decision and then struck down in 1954 by the Brown versus Board of Education decision. When analyzing civil rights law, you must ask three questions. First, who is doing the discriminating? Second, who is being discriminated against? And then third, what degree of scrutiny should be applied to that discrimination? I'm going to go over all three of those questions in that order, starting with this first one, who is doing the discriminating? First, we look at the federal government. Recall that the 14th Amendment is directed at state governments, whereas the Bill of Rights limits the power of the federal government. But there is no equal protection clause in the Bill of Rights. There is, however, a due process clause in the Fifth Amendment. So, whenever the federal government denies life, liberty, or property to a group of individuals, it violates or may violate the due process clause. And in that sense, the equal protection of the law is an aspect of due process. State governments are explicitly prohibited from invidious discrimination by the 14th Amendment. So when there is state action, the 14th Amendment clearly applies. But we have to define state action. State action includes laws enacted by state legislatures or administrative agencies, actions by employees of the state government in any branch, including state government employees enforcing private discrimination. When private discrimination requires the involvement of state actors, that involvement suffices as state action, and the 14th Amendment will apply. The textbook gives an example of that in the decision of Shelley versus Kramer from 1948. In that particular case, an individual was trying to enforce a restrictive covenant that a neighborhood had put in place prohibiting the sale of a home within that neighborhood to a member of the African American race. The seller and the buyer of the home were both fine with the deal, but the neighborhood association had a problem because of the restrictive covenant. And they had asked the courts to enforce that covenant by evicting the African American family who had purchased the home. But it was that eviction process that required the court's involvement, and because the courts are an arm of the state, any involvement of the courts would be state action, which in this instance, if state action was being used to enforce discrimination, that would violate the 14th Amendment's Equal Protection Clause. So in Shelley versus Kramer, the Supreme Court held that state action includes instances where state officials are having to enforce private discrimination. There must be a very strong connection between the state government's involvement in the private discrimination for this to work. The textbook gives examples of when that did happen and when that didn't happen, so you can get an idea of how it works. But state action does not exist when we're just dealing with private individuals acting on their own behalf. Private individuals and organizations are not prohibited from discrimination, so the 14th Amendment's Equal Protection Clause does not apply to them. Next, we look at who is being discriminated against. That's our second question. Civil rights law requires us to examine classifications. Remember the premise. Governments can treat groups of people differently, and many laws do. So civil rights protection depends upon which group is being discriminated against. Courts will only strike down laws that impose unequal treatment on particular groups of people. These groups are referred to as suspect classes. That is not because the members of the group are themselves suspicious, but because laws that treat them unequally are suspicious. What qualifies as a suspect classification depends upon 5 factors. First, does the classification reflect prejudice against a discrete and insular minority? That means that the group can be defined by a specific trait that only they share. Second, is the group's defining trait immutable? Immutable means that the trait cannot be changed. It is inherent to the group members and was not a matter of their choice. Third, is there a history of discrimination against that group because of their shared immutable trait? Fourth, does the group have the ability to seek political redress? This is connected to the previous factor, a history of discrimination. Courts consider whether the group had any political power when the law they are challenging was enacted. Was their voice heard in the democratic process that yielded the law? If not, it makes sense for the courts to step in and override the democratic process because it was not actually democratic. Voices were ignored. But courts might also consider whether the group's collective voice is heard in the democratic process now. And that makes this one of the trickier factors because many groups, such as African Americans, have much greater political power now than they did historically. Yet the law still considers race a suspect classification because of the long history of discrimination and white supremacy, and because of our next factor. Is that shared immutable trait relevant? A person's race is wholly irrelevant, so no law that discriminates on the basis of race could ever be valid, regardless of the political power or powerlessness of the racial group. Any combination of these 5 factors can lead to the designation of a classification as suspect. But for the past 50 years, no new group has received this designation. It is still limited to these 3: race, ethnicity, and national origin. There are, however, other classifications that are less suspicious but nevertheless protected. They are known as quasi-suspect classifications. They include gender and legitimacy. On an inconsistent basis, courts have considered a person's status as an alien a suspicious classification. Other times, it considers alien status a quasi-suspect classification. But when we say alien, we of course do not mean otherworldly, but rather non-citizens. It is important here to note that the 14th Amendment protects people, not just U.S. citizens. In 1886, the U.S. Supreme Court issued a famous decision known as Yick Wo versus Hopkins, in which the court made crystal clear that protection for civil liberties and civil rights extends to all people, regardless of their citizenship. In this module, I have assigned a video that discusses the case in order to emphasize this important point. No other group to date has been designated as suspect or quasi-suspect. Time will tell whether groups defined by sexual orientation or gender identity will be designated as suspect or quasi-suspect. The U.S. Supreme Court has a case on its docket right now that may require the court to definitively say whether those groups should receive the designation, but still time will tell. Sometimes it is easy to see the classification because the law itself explicitly singles out a group for discrimination. But other times, a law may be facially neutral and yet discriminatory in practice. This means that there is no explicit classification in the law as written, but it is applied in a discriminatory way that makes discrimination the obvious purpose of the law. Courts will consider both the language of the law as well as how it is applied when deciding if it discriminates against a suspect or quasi-suspect class. And that is another topic that is addressed in the Yick Wo video. Our last question to ask is, what amount of scrutiny does the classification deserve? Suspect classifications receive the strictest scrutiny because any law that discriminates against groups based on race, ethnicity, and national origin are inherently suspicious. So for the stricter rigid scrutiny test, the government bears the burden of both proof and persuasion. They have to establish that their law is necessary to accomplish a compelling government interest. The only law that has ever survived that test, it was the Japanese internment decision called Korematsu. It was assigned in a different module. And remember, even that Korematsu decision is an aberration, and it was later overruled by the U.S. Supreme Court. So when you see that the court has decided to apply strict or rigid scrutiny, you can pretty much assume that the outcome is going to be the court finds an equal protection violation. It is nearly impossible for the government to satisfy the burdens of strict scrutiny. Quasi-suspect classifications receive intermediate scrutiny. That is just referring to gender and legitimacy. Intermediate scrutiny also puts the burden of proof and persuasion on the government. The government has to show that their law is substantially related to an important government interest. Remember I said in some of the other module lectures that it is important to pay attention and to learn the very specific words used by the court in these tests. You really can't paraphrase them. You gotta memorize the actual specific words. So be really careful when you're looking at these tests and trying to learn them. Learn the specific words. That's why I've got a couple of those words on there italicized. But back to intermediate scrutiny. To review the holding of an equal protection case involving gender, well, that's to review the changing attitudes of the American public towards gender roles. Early on, laws denying rights to women were upheld. Now they are not. So if you're studying the laws involving gender classifications, you're going to see a change. We haven't been perfectly consistent in the application of intermediate scrutiny because attitudes towards the role of women have changed so much. And the VMI case that's discussed in your textbook is a really good example of some of the more modern ways that we are looking at gender classifications. Oh, and so you know, some cases have actually applied intermediate scrutiny to discrimination against men. So this really isn't something that only is considering women, it's considering gender, men and women. Either way, those classifications are given intermediate scrutiny. All other classifications are given rational basis review. And in those situations, the challenger, not the government, the challenger of the law has the burden of proof and persuasion. The test is the law, this is the challenger has the burden to show that the law is not reasonably related to a legitimate government interest. To show that it is not within the state's police powers or that the law is arbitrary. This test usually applies to cases involving age, economic status, and disability to the extent that they are not also impacting fundamental or individual rights. And also note that even if the 14th Amendment's Equal Protection Clause doesn't require strict or intermediate scrutiny, Congress still protects some of these groups, age and particularly disability, protects them from discrimination through legislation. And the textbook gives some familiar examples of that. But I just wanted to make sure you understood, Congress can give greater protection for civil rights than the Constitution does. The Constitution just sets a minimum threshold. Legislatures can give greater protection to civil rights than the Constitution does, and they have in this area. I'm not going to go into all the particular cases that your textbook gives about how these tests have been applied, because I understand you can read the cases for yourself and kind of see how it works. What I wanted to provide was just the framework so that you understand what the analysis should look like. And then you can look at those cases in your textbook as examples. I am, though, going to look at something your textbook also emphasizes, and that's voting. And the reason I'm going to go into these particular cases is because this is an area where the law is starting to change. Your textbook goes into really great depth on equal protection issues that arise in voting rights cases. And voting is an area where you see both civil rights and civil liberties issues arise. Your textbook notes correctly that when fundamental civil liberties are infringed by a law, the strict scrutiny test will apply then as well. In these voting right cases that your textbook describes, the plaintiff may be an individual asserting his or her individual right to vote, or it may be a group of people arguing that a law is discriminating against them. If that group is a suspect class, then strict scrutiny would apply all the same to the discriminatory treatment. So you have two bases there in these cases for using strict scrutiny. I'd like to draw attention to a particular voting rights issue, and that is gerrymandering. State governments hold the power to regulate the process of even national elections, and those regulations are usually respected, provided that they are not arbitrary, and your textbook gives a few examples of arbitrary laws, and also provided that they do not dilute an individual's voting power. That's where the issue of gerrymandering really comes into play. States use their regulatory power to draw and maintain the boundaries of single-member representative districts within their states. So you're going to have to look back to your studies in your Polls 101 class. Make sure you understand what redistricting is and why we do it. Why do we have single-member districts? Make sure you understand that. If you don't, you may want to give me a call. But anyway, getting back to it, states have used their regulatory power to, at times, redraw the district lines of single-member districts. To protect the right to vote, as well as the equal protection of each individual voter, these single-member representative districts should have the same proportion of voters to representative. This is to prevent the dilution of political power vested in any one individual. Equal protection rights are implicated when district lines are drawn in such a way that voting power is diluted, and this is known as the one person, one vote rule that upholds equality in the political power of the individual. State governments, though, are political institutions, and like most political institutions, political parties are calling the shots. When one political party dominates the state legislature, that state may use the redistricting process to pack voters of their party into single-member districts so as to create safe seats for the election of a representative from their party. This process is known as partisan gerrymandering. It may seem unethical to you. Partisan gerrymandering dilutes the voting power of individuals who identify with the non-dominant political party in their state because it prevents them from voting as a majority bloc in any district. The U.S. Supreme Court ruled in a 2019 case, Rucho v. Common Cause, that the Supreme Court, or any court, cannot hear partisan gerrymandering claims. The court considers them non-justiciable political questions. I've included a transcript of the court's syllabus from the Rucho decision in the reading material for this module so that you can better understand the court's position on whether they can review partisan gerrymandering claims. But for now, this is just treated as a political question, something that voters have to take up with their representatives through the democratic process. Equal protection is also implicated when the political power of suspect classes is diluted through the apportionment of representation across districts. The redistricting process cannot discriminate against groups based upon their race. The 15th Amendment, as well as the Voting Rights Act of 1965, prohibits racial discrimination in voting laws. I meant to read this to you. This is the language of the 15th Amendment. I want you to see it applies to both states and the federal government. Neither may enact voting laws that discriminate on the basis of race, because the 15th Amendment reads, "The right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude." So this amendment, the 15th Amendment, applies to both levels of government. The 15th Amendment has an enabling clause, and on the basis of that enabling clause, Congress enacted the Voting Rights Act in 1965, that provides protections against discrimination for races. And it goes a little bit beyond just the minimum requirements of the 15th Amendment to name specific things that states may not do, such as poll taxes and some of the literacy tests that were being used to disenfranchise African Americans. But there was another tricky practice that began occurring after Congress passed the Voting Rights Act. On the basis of that law, some states began drawing district lines in a way that packed African American voters into single member districts so that African Americans could form a voting bloc and easily elect a representative who would address their unique concerns. These districts were sometimes called majority-minority districts, and they worked. Many more African Americans were elected to Congress following the passage of the Voting Rights Act and the use of majority-minority districts. But now it seems the life of the Voting Rights Act may be coming to its end, as may be the life of majority-minority districts. There's a case currently pending before the U.S. Supreme Court addressing whether a majority-minority district violates the Equal Protection Clause. I have assigned an article for you to read about that decision so that you can be informed of what's going on. The case is called Louisiana versus Calais, and oral argument on that case was held just this past week on October 15th. You could even get a transcript of the oral argument if you're curious about what was being said. At a minimum, though, you're going to want to look at that article and make sure you understand what's happening in that case and keep an eye on how the U.S. Supreme Court ultimately rules. The last thing I wanted to go over is some of the one particular remedy for violations of equal protection. The textbook discusses a few of those remedies and also some of whether they were successful or not. I'm just going to focus on affirmative action. After Brown versus Board of Education was decided, the Supreme Court had to leave the implementation of that ruling up to local authorities. Well, those local authorities drug their feet, which resulted in an additional decades of segregated schools. But ultimately, we saw legislative efforts to rectify past segregation in the form of busing, rezoning, school choice, and magnet programs. So we started seeing those things happen in the 1980s, and affirmative action was among those efforts. Affirmative action is just another method to promote equal access to education, but it is also used in employment practices. And it uses race and gender-based classifications. And because of that, the court is going to apply strict scrutiny. Affirmative action, like most of the other methods or remedies for equal protection violations in the past, were controversial because it makes race a factor in decision-making. The textbook discusses the major cases on affirmative action, but a new case was decided after the textbook was published, and I've assigned a case brief of that decision as well as an article that describes it. The case is called Students for Fair Admissions versus the President and Fellows of Harvard College. There was a sister case that was heard at the same time involving University of North Carolina. So those two cases are combined, and the decision is applied in both of the cases. The same decision applies to both. So you should read the textbook's discussion of the earlier cases, the Bakke case, the Bruckner case, and then read this article about the Harvard case so that you can see the progression of the law and learn the reasons why the court struck down Harvard and UNC's admission policies. Many scholars, though, and this is interesting, another reason why you want to pay attention to that voting rights case that's currently before the court. Many legal scholars believe that the Harvard case signals an end to policies that seek to diversify their student populations if they place any weight at all on a student's race. The court's argument is that using race as a factor in admissions violates the Equal Protection Clause. By giving favoritism to one race, you inevitably disfavor the others because there are only a limited number of spots available for students to fill. That argument is similar to the one being made in the voting rights case, Louisiana versus Calais. Majority-minority districts are a similar remedy to affirmative action. So the court's holding in the Harvard case may weigh heavily on the court's next decision in the Louisiana case. So pay attention to that case. Read the article and then keep your eye on the news to see how the U.S. Supreme Court ultimately rules. That's all I've got for this module. Study your textbook and the other reading assignments. It is a good bit of reading in this module, so you're going to want to make sure you set aside plenty of time to get that reading done. And send me any questions that you have, or if you find anything confusing, even things that I didn't go over in the module, I'm happy to explain to you one-on-one.